This courtroom session starts off with confusion, missed court dates, and a defendant already on thin ice with the judge. But what seems like a simple scheduling mistake quickly spirals into a lesson about accountability, responsibility, and how small oversights can snowball into serious legal consequences. As we move forward, you'll see how the judge reacts to excuses, how different defendants handle pressure, and how quickly the tone shifts from leniency to strict enforcement. Stay with us, because some of these moments are not just shocking, they're brutally real. And the question is, would you have handled this any differently?
Joshua called like
You're being show-caused.
yeah, I just got confused about the whole process. I had spoke with a prosecutor via a Zoom call back at the end of November, and he said something about being able to do a pro.
I adjourned it to December 2nd, and you were supposed to be here then, and you didn't show up.
Okay, I didn't even notice that. I didn't get that told. I don't even know if I got that notification.
Well, you came in front of me that day, right?
No, I didn't.
Oh.
And like I reached out to try to understand what happened after the second there. Nobody contacted me back. I tried via email and some phone calls, and I have the emails from the prosecutor on my phone.
Right here, the judge calls out something critical: lack of diligence. In legal terms, this is huge. Courts operate on strict timelines, and missing even one appearance without proper follow-up can lead to default judgments, additional fees, or even warrants. What's striking is how the defendant admits confusion but didn't take proactive steps to confirm his obligations. This raises an important question for you watching. If you were unsure about a court date, would you double-check immediately or assume everything is fine? Because in court, assumptions can cost you.
You weren't very diligent, were you? You didn't think I adjourned it until 29, did you? 2029. I mean, come on. I adjourned it a week,
Okay,
and then you didn't show up.
I wasn't aware of that. Sorry.
Well, did you move?
No, it should be 7200 Drive.
7200 Richmond Drive.
Yeah.
We told you to appear in person. We sent the notice out on the 25th of November. We sent it to your address.
Okay.
I told you to appear December 2nd at 9:15, and then you didn't. And I entered default, and then we sent you notices, and you didn't pay, and then we initiated a show cause.
I didn't realize that I needed to show. Sorry.
What'd you think was gonna happen?
I was trying to contact to understand what.
This is March.
Yes.
We don't take this long to deal with civil infractions.
Yes, sir.
If I did that, we'd have to build a 15,000 square foot addition on here to store all the files.
Yes.
You owe 200 and $13. Do you have that?
Yes.
And then you have a $35 warrant fee. You made a mess out of it. What do you do for a living?
I work for FedEx. That's one of the busiest times of our year. This is in December, and
We're all busy.
Now this is an interesting turn. Despite the frustration, the judge actually shows leniency by reducing the total amount owed. Instead of escalating penalties, he gives the defendant a chance to resolve everything with a lower payment. This highlights something important about courtroom dynamics. Judges often balance accountability with fairness. But notice the warning: be more responsible. That's not just advice, that's a final chance. Do you think the defendant deserved this break, or should the court have been stricter?
I'll make it 200 and I'll waive the balance for you.
okay.
You pay 200 now, balance waived, okay?
Okay.
Be more responsible, will you? How old are you?
Almost 40 now.
40?
Yeah.
What are those? Nicole Lane Schultz, 26W841617A. B.
We're down.
I'll be with you momentarily, Mr. Sparrow.
Oh,
Your name? You're charged with driving on a suspended. You have the right to an attorney. If you want one, I will appoint you one. Would you like one?
No, I don't.
All right. I'm gonna go ahead and arraign you then and send you to the prosecutor.
Okay.
On February 20th, 26, it is alleged that you did operate a motor vehicle with suspended license on Judith near West and Woodhaven. That is a misdemeanor. That happened at 11:42 in the morning on that date in Woodhaven, and that is a misdemeanor punishable by up to 500 fines, 93 days jail. Costs are all those at 2 points. Do you understand that? Did you sign, read, and understand an advice or rights form here today?
My hand was shattered and it's my dominant hand, so I can't write.
Jeez, I'm sorry.
That's part of the reason why I got pulled over. I was on the way to the hospital to get my
Slow down, slow down,
I was on the way.
slow down. I just want to know right now, and I'm sorry you're going through that. Did you read this form?
Yes, I did.
Did you understand all the rights on this form?
Yes.
If you plead guilty, you're going to be giving up all these rights, and we're not going to have a trial of any kind. You understand that? All right.
This moment is a perfect example of how quickly legal decisions can shift. The defendant initially waives the right to an attorney, then suddenly hesitates. That's a big deal. In the legal world, waiving your right to counsel means you're choosing to represent yourself, and that can be risky, especially in criminal cases. The judge steps in and corrects course by entering a not guilty plea and appointing a lawyer anyway. This shows the court's responsibility to ensure fairness, even when defendants make uncertain decisions. But let's be real, would you ever walk into court without legal representation?
Now, do you still wish to waive your right to a lawyer?
I can get a lawyer. Yeah. I wanted, can I talk to one? You guys
I
have.
thought you said you waived your right to a lawyer when I first asked you. Did you do that or not?
Yes, I did.
Well, here's what I'm gonna do. I'll enter a not guilty plea. I'll give you a $500 personal bond. Here are your bond conditions. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. I'll just appoint you a lawyer now. John, give it a lawyer. We'll send you to the we'll send the lawyer to the prosecutor. You have a defective equipment civil infraction charge as well, by the way.
What's that? I'm sorry, I don't know what.
Defective equipment. They said you didn't have a brake light working.
Oh, yes, there was no break, right?
So go talk to the lawyer. The lawyer will go talk to the prosecutor for you, and then you'll come back in front of me, okay?
Okay, thank you.
Good luck. Abakar Hussein. 267841640. Who has Mr. Hussein? Is anybody, do you have Hussein?
Yes,
Come on up here.
just. I thought everyone knew what impeding fact.
What do you mean? Somebody didn't know?
What? Yeah, is that good? I'm like, yeah, that's good.
All right, your appearance?
All you have to ask Mr. Hussein.
Do I have an appearance? Yes, I do. You're authorized to enter this plea. You're gonna plead to impeding, true? To that charge, responsible or not responsible?
Responsible.
Please accept that it's a commercial vehicle, 180. I'll give them until the 25th to pay, okay?
Okay, sounds great.
Have a great day.
Zero?
Pardon?
Did you say 180?
180. Right, thanks.
Yeah.
Cruz. Dustin Antonio Cruz. 26W841491. Your name?
Dustin Bruce.
You're charged with parental responsibility violation. You have the right to an attorney. Would you like an attorney? Okay, we'll give you an attorney. You need to go out in the hall. We'll set you up. Ma'am, you need to go out in the hall too.
I said sit down right here, I'm sorry.
That's okay. And then after you speak to the lawyer will go talk to the prosecutor for you, okay?
Yeah, thank you.
All right, no problem. All right. All right, Reginald Steve Wilson Jr., 25G149900A. All right, good morning.
Good morning, Rob. Hi, good, sir.
your appearance?
For the record, James Sparrow, appearing on behalf of Mr. Wilson, time to be accepted for testing.
Sir, your name?
Reginald Steve Wilson Jr.
He immobilized his vehicle, correct?
Yes, he
He's
is.
on the sober link device, correct?
Yes, he is.
He wants to get into sobriety court, is that correct?
Yes.
Is that what you want to do?
Yes, sir.
You sure you're up for this?
sir.
You know it's not easy, right?
Yes, sir.
You're gonna be there today, right?
Yes, sir.
All right,
I'll be here at 3 p.m. sharp.
all right, good enough. Did you have a chance to review the report with him, and are there any material additions, corrections, or deletions?
I have, Your Honor. It is factually accurate.
Anything that you would like to say on his behalf?
Your Honor, I represented Mr. Wilson on the prior offense also. I've spoke with him in detail about this. I told him when the sobriety court was an option that you would be very candid, and at times you almost, tell defendants that how difficult it is, and almost tell them like, hey, don't do this if you're not gonna take it serious. He knows.
Here we see a completely different tone. This is about rehabilitation, not punishment. The judge is talking about sobriety court, which is designed to help individuals recover while staying accountable. But listen carefully. The lawyer emphasizes that this program is not easy. It requires discipline, honesty, and long-term commitment. This isn't just about avoiding jail, it's about changing a life. So here's something to think about. Do programs like this truly help people reform, or are they just another form of strict supervision?
Exactly what's expected of him. I've followed up with clients over the years about the program. I've told him, some of the success stories and some of the how it's changed some of my clients' lives. The resources and the structure of the program are fantastic. He knows what's expected of him. This isn't an opportunity for us to tell you what he's going to do. It's for him to show you what he's going to do. And I hope he does really well with this and enters this with an open mind, which he is.
Anything you would like to say, sir?
Not really, Your Honor. Just ready to get this started and do what I gotta do.
All right, because this is not good. You had two within about 18 months. This is a 199, so we got to get this under, we got to get it under control, okay?
Yep.
All right, 2 years probation. I'll be glad to take you. But remember, this is a marathon. This is not a sprint. So I'm sure you're not finding things easy right now. As time goes on, you'll find it a little bit easier. But nobody has ever heard me say that this is an easy program to get through. But in the end, you are going to have changed your life dramatically, and it's going to be for the better. So I'm sorry, 2 years probation. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You change your address, place of employment, or home telephone number, you must notify probation. You have to report as direct. You're to comply with all agreements, guidelines, and requirements as set forth in the sobriety court participant handbook. You're not to purchase, possess, or consume alcohol. You're not to purchase, possess, or consume illegal drugs or marijuana. No alcohol, no drugs, no marijuana. Submit to chemical testing on demand of probation. We're going to start to pay for these tests. As long as you show, and you show every time, and you test negative every time, we will be paying for your tests with our grant. If you miss a test, I'm going to consider it a positive. I'm going to consider it to have been a positive test. And you're going to be subject not only to sanctions, but you're going to be paying for those tests for a while. Okay? So submit to chemical testing, PBTs and ETGs on demand of probation. You've been on the sober link for, correct me if I'm wrong, it's been about 2 months, right?
Yes, about that.
75 days more on the sober link device. Attend AANA 12-step meetings at least 3 times a week and provide proof of attendance. Obtain an AANA sponsor. Attend all substance abuse treatment as directed by probation. Attend the Victims Impact Panel. Attend the Armed Specialty Court Weekend Program. Report to sobriety court status review hearings with me every 2 weeks. You can come at either 7:30 or 3 o'clock. That's on Wednesdays. Although we're going to be moving The one on Wednesday is a little bit, so I'll make that's gonna be Tuesday afternoons going forward pretty soon. You're to obtain and maintain employment with proof provided to probation. In terms of fines are going to be 200. Costs are going to be 200. $75 victim's rights fee, $50 justice assessment. So your fines and costs are only $5.25. Your screening fee is $60 for $585. You have probation fees of $480. Bring your total to $1,065. Sobriety court fees are $360, bringing your total to $1,425. And then
Now we're getting into the financial breakdown, and it's intense. The fines, fees, probation costs, and program expenses all add up quickly, reaching nearly $2,000. This is where many people underestimate the legal system. It's not just about the ruling, it's about the long-term financial impact. And the judge makes it clear these costs can't be reduced further due to mandatory fees. So ask yourself, should the system be this expensive, or is this necessary to enforce accountability?
you have cost of recovery. This was a blood draw for $2.25. All right, so I'm sorry, Amy, what did I just say the fee, everything was until I added in cost of recovery? Can't remember. 200, 400, 5.25, 585, 985, 1,065, 1,365, 1,425. The total here will amount to 1,650. Now, there is a problem though. If you weren't getting in sobriety court, I think I made clear you'd be going to jail. Did I make clear of that? Yes?
Yes.
So I want you to know, right now, you're saving yourself. But no violations. Okay?
Yep.
I'm gonna order 10 days jail credit, 1 serve 9. I'll let you serve all 9 on the court work program. 9 days court work. 9 days of court work program at the rate of $35 a day amounts to $270, $315 plus the $1,650. I can't keep these fines and costs any lower. Or I just can't make them lower with all these fees that we have to add in. $1,965 is your total.
This is a pivotal moment. The judge lays out the consequences in plain terms. Violate probation, and you could face up to 93 days in jail. That's not a warning, that's a line in the sand. But at the same time, the judge offers a structured payment plan, making it manageable for the defendant. It's a mix of pressure and support. This balance is what defines many courtroom decisions. Do you think this approach actually motivates compliance, or does it still put too much pressure on defendants?
If you violate, your probation could be revoked. You could be incarcerated for 93 days with credit for 1 day served. So that is the sentence of the court. You have 21 days to appeal. You have 14 days to apply for a court-appointed lawyer for purposes of appeal. I look forward to helping you. I really do. How much of this, can he pay all of this today, Mr. Spiro?
Your Honor, could he have a payment plan?
All right, how much does he have today?
Yeah, I will not be paid till Friday.
Get paid weekly, right?
5 weeks.
All right, I'm gonna give you a payment plan. When you get paid next?
Friday.
This Friday?
Yes, sir.
Judge, he also has the outstanding PBT, just if you're including that in the payment plan.
On file B here, my apologies. Fines costs of 200. I'll make it 200. I'll cut them down a little bit. So I'll, not much, but fines cost of 200. And I'm gonna ask you to pay that one. Can you pay that by Monday?
By Monday, yes.
You pay that one by Monday, which is March the 23rd. And then I will set you up on a payment plan of $125 bi-weekly. Can you do that?
Yes.
You pay $125 bi-weekly, and I'm gonna start that beginning on April the 6th. Okay?
That's it.
That's it. You'll meet with probation. I think they're gonna cover some other aspects with you. We'll want to get the sober link changed over where we're paying for that now. Again, just make sure you're blowing into it and you're doing everything, okay?
Sir,
Good luck.
Thank you, Your Honor.
Thank you very much, Mr.
see you this afternoon.
All right, sounds good. Good luck.
Thank you.
Nolan. Terrell Nolan. What? Did you meet with the prosecutor, Mr. Holmberg?
He did, Your Honor, and Lieutenant Toller is bringing the file in right now.
Okay.
Yes, Your Honor, that's correct. We did.
Okay, 23B147631. Mr. Nolan, your name? I took your plea December 4th of 25. The charge was failure to complete the positive strategies program at 4-week follow-up. What is going on here? Now the prosecutor's saying you request a month adjournment to complete it? This is March. Why haven't you done it?
I don't have an excuse.
Well, then, come on. I'm not gonna beg you to do these things. You don't wanna do it, don't do it.
I don't want to do this.
Well, no, you don't wanna do it. Listen to me. I sentenced you back on March the 13th of 25.
And ever since this all started, my life has changed like 180. So I'm going through a lot of stuff, trying to do a lot of stuff and handle a lot of stuff. This did go over my head only because I just started 24-hour shifts. So it did go over my head, but it's not something that I did on purpose or intended to miss. That's why I show up every time there's a court date. I don't mean to do it on purpose, but I do want to get it done. That's why I'm asking for the extra time because I'm already enrolled. My first date is on Monday the 23rd.
Call in the prosecutor, please. I don't understand. I just don't understand.
Now this situation feels different. This isn't confusion anymore. It's repeated delay. The judge is clearly frustrated, and you can hear it. When someone admits they have no excuse, that removes any legal justification. But then the defendant explains personal struggles and work pressure. This creates a conflict between accountability and empathy. Should the court consider personal hardships more heavily or stick strictly to deadlines? That's a tough call and one that courts deal with every day.
I don't understand. I told you to do it December the 2nd. Well, this is March the 18th.
I did the first part of the class, but then, like I said,
I don't even know why the prosecutor has anything to do with this, to be honest with you, except this is a review hearing date.
Yeah.
I'm gonna need Caitlin Foley Carter. Did I take this under a statute? Amy, 771 maybe? Your name?
Caitlin Foley Carter, Bronson Township.
I'm not sure what's going on. Did I take this under a 771?
I believe so, Your Honor.
I don't know why I set a review hearing date. Amy, I need to check
I don't-
something.
I don't see that you took it under a special status.
Either. And it's a review, but I wrote down here to set a review hearing date, and it was set for March the 4th at 9 a.m. And I wouldn't do that unless I was taking it under a statute. Let me just double check something here.
It looks like Lisa made a note on 325 that said not taken under deferred status.
Oh, yeah. So he really shouldn't have even seen you. This is just a new show cause for failure to attend the positive strategies program.
Understood, Your Honor.
That's so that, I just need to be clear about that. I'm sorry. That probably was my fault. So I'm gonna go ahead and arraign you.
Thanks, Your Honor.
I'll give you a lawyer if you want. You're charged with failure to attend the Positive Strategies Program with 4-week follow-up. Says you attended the intake session but failed to appear for the follow-up appointments. If you plead guilty or if you were found guilty, this would be a second technical violation. And you could get 10 days. Do you understand that?
Yes.
Did you sign, read, and understand an advice of rights form here today? If you plead guilty, you'll be giving up all those rights, and we're not going to have a hearing or a trial. Do you understand that? All right. So you have the right to a lawyer. I'll be happy to provide you with one at public expense. Would you like a lawyer? Are you sure? To the charge, you failed to attend the Positive Strategies Program with 4-week follow-up. How do you plead? You failed to attend the Positive Strategies Program with 4-week follow-up. I can't hear you.
Yes.
Anybody force you to plead guilty?
No.
I need justice. So you went to the intake, correct?
Yes.
When was that?
I don't recall the initial date. I know it
Was it in 25 or 26? When was it? January, February?
I think it was, I honestly can't even. I'm sorry.
But you failed to attend and complete the program. True? True?
Yes, I think the first part, the 6-hour part, and then the next Monday session is what I missed due to.
All right. I'll accept your plea. I find it to be an accurate plea. Made voluntarily and understandingly. The plea is accepted. All right. Your name, please.
Let's vote on
I don't know what he's doing. What is he doing here? When was the intake session?
The intake session he had, let me double check and see. So he appeared for the intake session back in January 22nd, and then missed the follow-ups as scheduled.
Where do you work?
Superior in Taylor, and then another station in Mill. Do 24s at Taylor sometimes, and then I do 13 hours at
Doing what?
EMT on that ambulance. Literally just
You're an EMT and you're acting like this?
not like I said, since the first time I met you, I've been trying to change everything around.
What do you mean change everything around?
My life, just the path that I was going down.
What path were you going down?
I was just, like I said, I met you, I was going down a bad path. My wife was pregnant, about to get married, so I'm trying to turn everything around. I'm about to crush this.
You're about to what?
I'm trying to just turn everything around to make it better for my home.
How old are you?
I'm 27, just turned 27 in February.
You're a well-spoken man. And you have been a year on probation and you're still playing around with this.
But I am playing around. I'm not trying to go. I'm trying to get it done as quick as I can. I just miss some opportunities.
What do you want to say?
Class is completed, it's only the class that's left for him. He completed all of his time costs are paid in full, he completed all his coursework program days, he cleared his warrants up as ordered. It's just this remaining class, just the follow-ups. And from what I checked right now, that doesn't seem like the follow-ups are scheduled until May.
Oh no, they said the first one starts. It's Monday.
It's Monday, okay, perfect.
He was scheduled to come off probation on March the 13th, right? How many hours you working per week?
It's been like 40, 60. I'll try to get as much time as I can because I gotta pay for the wedding. So that's in 4 months.
This is your last chance.
Okay.
Serve a day on the court work program, pay $30 for that. Probation is extended until June 13th for a period of 3 months. Additional cost is 60, additional probation fees is 60. Your total here is 155. Defendant to complete positive strategies program. You seem like a nice guy, but you gotta, I don't understand. Get this taken care of, or I'm telling you, I'm not gonna be this nice next time. We understand one another?
Yes, sir.
I thought we understood each other last time.
You did it. Yeah.
All right, enough said. Go down the hall, take care of that, talk to her. Good luck, and good luck on your wedding. Ramona Stokes.
This entire courtroom session highlights one powerful truth. Accountability is everything. From missed court dates to probation violations, every decision carries consequences. We saw moments of leniency, where the judge reduced fines or offered second chances. But we also saw firm boundaries, especially when patterns of negligence started to appear, whether it's financial penalties, probation terms, or rehabilitation programs. The system is designed to push individuals toward responsibility, but it's up to them to follow through. So what do you think? Were these rulings fair, or should the judge have been stricter? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.